Hi everyone, welcome to this webinar. Yes, Neha, hi. I was just opening the webinar. Meanwhile, I would just like to thank you all for attending this webinar and joining in, taking out time out of your busy schedules. So we'll be discussing about. We have Neha with us, by the way. So she'll be starting her video in a couple of minutes. So we are going to discuss the process of research today. Now, I clearly don't know how many of you are law students and are working professionals, but trust me, legal research is something which everyone needs, like in our day-to-day work. So in this webinar, we will be covering like four broad themes. So first is how research was taught to us in law school, or how is taught to us in law schools. The importance of field work in conducting research, right? So again, we will explain like how field work works and what's the importance. Then we are gonna discuss about how to arrive at data-driven research, and then we will be discussing about the importance of a hypothesis. So that's the these are the themes which we'll be covering today in the webinar. Yeah, we will be taking up questions, once the speaker has finished explaining some of the points. So we
All right.
have Neha today with us. Hi. So Neha is a senior resident fellow with Vidhi Centre for Legal Research and Policy, and she has worked in the area of criminal justice. Neha, you can talk about your work, and share your experience with our attendees today. So Neha is an LSIU graduate, and she has also completed her LLM from University of Kent. So Neha, like I told you, it would be great if you can tell us about your research. We want to hear it from you. So over to you, Neha.
All
The
right.
floor is yours.
So I'll start with giving you a brief introduction about my career trajectory. I graduated from National Law School in Bangalore in 2008. I did my master's in criminal justice from University of Kent in Canterbury from 2009 and 10. I litigated in trial courts in Bombay in criminal matters in till 2012. Then that's when I got into like academia research after that. So I worked at NLU Delhi for 2.5 3 years. I was co-heading. I was the deputy director of this mega study on death penalty that NLU Delhi conducted in 2013-14. From then I taught legal history for a while. And then since 2015, I've been in Wiki and I have been researching on the NDPS Act specifically, but generally looking at how criminal law functions or the role of criminal law in society largely. So that's been the themes of work that I have been doing. So, the first point that that I thought I will cover is what law school teaches us about legal research. And I thought about this for a while, and I spoke to some of my classmates also about what we were taught in college about legal research, and we realized that we are actually not equipped while we're in college to really conduct legal research and how it should be conducted. So one thing that I want to start out by saying is that legal research is not a monolith. It is not one act or one thing that we do. It is something that everybody who studies law has to do. So, when you're a law student and you're asked to do legal research, make projects, research projects, the idea at that time is for you to get familiar with research, with reading, with forming analyses, with, thinking about things like a higher order than what you have been used to thinking. Like, for example, if say criminal law, let's say I have a project on criminal conspiracy. So then I will have to think about what what the provision for criminal conspiracy is, what 120 section 120b says, what the case law around criminal conspiracy is, how the precedents have evolved, what are the kind of cases that criminal conspiracy generally gets used for. So you will find that in most cases terrorism cases include criminal conspiracy because they have so many people that they need to have this provision of criminal conspiracy to be able to convict or arrest everybody who's involved in this planning, so to speak. So law students are generally told to do legal research to sort of help them equip themselves with law and how law functions. So the first thing that I would like to start out by saying is that, because I just said that legal research is not a monolith, I started out by saying law students because I assume that a lot of you are law students. And my my first step would be to tell you that legal research would look different according to the groups that you belong to. So for example, law students will research law the way I just said. A litigating lawyer will research on law because the audience or the person that you or the thing that you're researching for is the court. So your legal research will be precedence based, statute based, and your audience is the court. It's the court that you need to convince with the stellar quality of your research. If you're a law firm, like if you're working for a law firm, you still have to do legal research, but it's going to look different. It's going to be on a point of law that your client needs your help with, because if they need to make a certain claim with the government, or they need to have certain leverage over another party, then it will depend, that legal research, the precedent on that will help them make that argument. The two kinds of research that we at Vidhi deal with are policy and academic. They just research for the sake of creating knowledge. So now these two things again are very different. One is policy, where you are now determining law or governance. So you still have an audience. Your audience here is going to be a politician, a minister, a bureaucrat. So you're going to, now your research will look different. The kind of things that you will look for are going to be different from what an academic research is going to do. So an academic research is going to be for audience and for knowledge creation, right? When you read an academic paper, it is just to inform you about things in life, which is different from any of these other different audience driven or client driven research. So the first step about legal research is to know your audience. I'll come back to this towards the end when I'm talking about the writing of the paper or how you write legal research. But the first thing, just starting point, is that different groups have different audiences. And these different audiences are going to determine how you conduct research. I am going to focus on academic research and research for research's sake, because that's what I do. But you have to, depending on what your career paths take you, you have to understand that you will learn research differently, and don't fall into this trap of thinking research or legal research is this one trick that you can figure out and that will give you answers to all different kinds of research, because that's not how it functions. So there is in say a law school project or the kind of work that I do, is the first question you ask is, what is your research question? So your research question will then determine the hypotheses that you make, or at least will determine how you continue researching. Because, so for example, the latest piece of research that I have put out is on criminalization of drug use in Bombay, and how people who are consuming cannabis are disproportionately getting arrested and convicted in Bombay, which is driving up the arrest rates under NDPS Act, and driving up conviction rates and disposal rates, and basically it is giving an illusion that the criminal justice system is functioning very effectively in Bombay. But what it is actually doing is that it is picking up the most marginalized and vulnerable people who are usually caught smoking weed in the middle of the road in the middle of the night. And these people are brought to court and convicted. So this is the study that I did, and this is what it found. So now, if I have to think about how I will conduct this research from the first step, is that I am going to have a research question. My research questions could look anything from, why is drug consumption an offense? Why should this is another thing again, considering that you might be law students, that I think I must flag, is that a lot of times we look at law as an absolute. We start with the point saying it's a crime, it must not be done. But what research gives you the tools to do or the freedom to do is question why a certain thing is a crime in itself. And I am, again, this could be that question could be on anything. Why is, I don't know, again, I think so much in the realm of criminal law that I can't think of outside criminal law examples, but what does death penalty, for example, does death penalty actually deter criminals? So this is like a very first order one question, that why is drug consumption a criminal offense? Or what does criminalization of drug consumption lead to? So now this is my first question. Now, how do I go about finding answers? Some of the answers are going to become your hypotheses. So your hypotheses could be, Drug consumption is a criminal offense because people fear the law, and people will therefore not commit, will not consume drugs, and that will lower drug consumption rates. Or what does criminalization of drug use lead to? My hypothesis, my tentative answer to this could be that criminalization of drug use leads to exploitation of the poor. Okay, this is just an example. So your hypothesis is going to be a tentative answer to a question that you have posed. This need in a hypothesis is a very important aspect of research, but one, like, I often conduct my research without having a hypothesis. I just start with research questions and then see where those research questions take me. So I have my method of conducting research is very exploratory. It's stepwise, forming a question, thinking about what I need to do to go about answering that question, and then conducting that research and finding my answers. So this is the first step of a question has been asked, a broad question has been asked, and now we have to look about how we answer that question. The first step to answering that question is to have a literature review, a solid literature review in place. What does literature review mean? Literature review is basically looking at all the work that has been done on that question or around that question in your domain. So for example, you're going to look at case law. Does case law exist on this point that you're asking? Then you're going to look at other kinds of reports that have been done on this particular issue. Then you're going to look at commentaries, you're going to look at academic journals, you're going to look at if there is an intersection between between social sciences and law, then you might look at sociology papers, you might look at criminology papers. So you're going to have like an exhaustive reading on all that has been done. And you have to now identify your sources. What are your authoritative sources that you can cite? So your legal precedent, of course, is an authoritative source. Your JSTOR and the articles in Harvard Law Review are, of course, authoritative sources. But for example, Wikipedia is not going to be an authoritative source. You could start to inform yourself what the point in question is, but Wikipedia, for example, is never going to be an authoritative literature review source. So you look at all the information that is available. You then identify what this information tells you, whether it's chronological, whether it's thematic. So say in drug consumption, I can say that I would have literature review on, this is very interesting, literature review on context setting would be, so in 1985, if the NDPS Act was enacted, then what was the legislative consensus or discussions around criminalization of drug use? Why did we criminalize drug use? Why did we criminalize cannabis? What were the reasons what was happening at that time in 1985 that made us criminalize cannabis? So then you're going to look at the international factors that led to this. So for example, in 1961, India was a signatory to an international convention on narcotics, which made cannabis one of the prohibited substances. And India had, I think, 20 years to implement that. So by 1985, they were forced, because they were signatories to this international convention, they were forced to have cannabis as a part of their law. But in the conversation, in the legislative discussions, you will find that they are not comfortable criminalizing cannabis, that they are a little, because they know its historical use, they know its cultural relevance, but because their hands are tied, you know that they have criminalized cannabis. So now you have set a context on saying why cannabis was criminalized in the first place. So 35 years hence, we are looking at cannabis, we see the debate that's happening on television right now, we are looking at marijuana as a drug. It's a bad thing and people are consuming drugs. But we realize that the very law that makes it a bad thing was not comfortable making it a bad thing. That has been your context setting. You have set it at that time. Just criminalization of drug consumption. So you realize that the reason why they made drug use a criminal offense is because they thought, like what I had started out by saying, that people will be deterred from using drugs if they know they can go to jail. So now your hypothesis could say, or your research question could say, that at the time of drafting the NDPS Act, the assumption was that sending people to jail is going to deter them from consuming drugs. 35 years down the line, has that assumption borne fruit? Is that assumption correct? And then you can do, this is where your preliminary research on this is done. You can look at what courts have said on this. Has this matter gone to court? Has drug consumption ever been presented before a court? Have other organizations worked on this? You will find other organizations, given what this issue is, you will find medical journals on this. You will find AIMS, for example, has written a lot of reports on drug consumption and criminalization and the stigma that comes from criminalization that prevents people from assessing de-addiction facilities because they're afraid that they will get arrested. So how criminalization is actually preventing people from accessing health-related services. Now, these are things that are done in your health space. But what we found, for example, is that there was no work done on using Section 27, which is the provision that criminalizes drug consumption, no work done on how the law has panned out on the ground, in the sense of using law as your lens and not using medical data as your lens. So now you have looked at your research, you have looked at all that has been said about this internationally, nationally, who has said what. Now, once a literature review is done, that's when you know how you can plug the gaps that have been left by other people. What value add do you bring in? Because if you're only going to regurgitate and repeat what somebody else has already said, then there is no real value addition that you are bringing to the table in this form of research in any case. So the next step would be to identify what it is that you can do, how you can say, and what it is that interests you in that gap. There might be many gaps that haven't been filled. What gap do you want to fill? And then the next step would be how you go about filling that gap. I'll take a break here in case anybody has any questions. Anisha, if there is anything that anybody wants to say.
Right. Neha, the one question which is coming up by a lot of attendees is how to select a research topic, you know. I think when you are a student and you want to, write something, you want to research about something, we are at times lost. Okay, and if there is a hot topic, there might be a lot of people already writing on it. So, if there's something going on, let's say the GDP falling, then how to find a research topic where you can write and actually contribute towards the topic through your writing?
So I think there are two aspects to this question. One is how to choose a research topic. I would say if you're doing this, if it's a job specific requirement, your job will tell you what research topic should be. So if you're arguing a matrimonial matter, you know which provision of law you need to research on. So that I think is already predetermined for you. If you're being a legal researcher for the sake of research and you want to add to the conversation that is happening, one could just be to pick up a topic which is interesting to you, which hasn't been said of very much. For example, one of the things that I'm working on right now is preventive detention in India, and beyond Article 22 or National Security Act and UAPA and all of these, what is the state of preventive detention in India? Why do we have it? And what brought it on in the Constitution? What brought it on in national laws? What brought it on in state laws? So this was an idea which was interesting to us. We thought it's not been done before. Nobody has looked at it. Let's look at it and see where it goes. One could just be your flight of fancy on an issue that you're interested in. Another thing could be if you see that there is GDP or GST or whatever, that there is a lot of writing on this. Then what you do is look at what I just said about literature review, right? You look at what is being said around you. If you have nothing new to say, you can still say it if you write it well and if somebody will publish it. But the wiser thing to do when you're actually contributing to the conversation is to see what isn't being said. So there are a lot of things that can be said on a certain topic, right? So what is it that hasn't been said and you have something to say? So I don't know how to, okay. Again, because this is what I'm doing and this is the context in which I'm thinking right now. So with all of this Riya Chakrabarti conversation, what I think hasn't been said or what isn't being talked about at all in national media is whether drug consumption should be a criminal offense. Right now, we're only saying, oh, she's committed a crime, oh, NCB is on something, oh, so much consumption in the country, we must catch the criminals, whatever. But nobody is looking at whether this particular offense should even be an offense. Now, this is like a conversation that I can contribute to, which I have worked on, which I think is an interesting idea, and that isn't being discussed in media, in writing. So let me now start thinking about it from this point of view. So there is always a little hole that you can fill that hasn't been said. Another like example that we looked at, our previous report was also on NDPS, was working on the NDPS Act in Punjab. The reason we looked at that is because in that around that time, around the Urda Punjab time, everybody was talking about drug consumption, drug abuse in Punjab, and how it's a terrible situation. There was a lot of literature on the social factors, the economic factors, the Green Revolution, its proximity to Afghanistan, Pakistan, and the drug route. It talked about narco-terrorism in the 1980s and how the Khalistani movement contributed to this. What there wasn't anything on was how the NDPS Act, just the NDPS Act, was making the situation worse. So we thought, let's look at law, let's make law the protagonist of our story and see how the NDPS Act is making the situation in Punjab worse. But the function of the law is to make things better, but it's actually making things worse. So that was like this unique lens that we brought to the conversation that hadn't been said. So that's how you choose your research topic, if that helps.
Right, Neha. I think this completely makes sense. So there's another question. Okay. So this question, I think there are a lot of questions actually. We have 30 questions. So I'll just take some of them for you. Okay. Could you elaborate on how to set the limit to a research, like basically the nature and the scope? So this question is by Mona Lisa. So she's also written, cause it is really overwhelming when we deep dive into any topic and there is no end to it. So how do you set a limit?
Is this Mona Lisa that I know? I wonder. Anyway, the answer to that is really your own judgment, because this deep diving and going down a rabbit hole is a real problem, and all researchers face it. We know that this is like the real researcher's quandary where you're just stuck. You have to. There are. I think, and this is a very personal, intuitive answer, is that there are times that you know that you have made a good argument. That, and your argument at the point that you're making it can only go so far. Like, for example, again, because I've been using this, should drug use be a criminal offense at all, is a question that I started out by asking, but I changed the scope of my question, saying that is section 27 of the NDPS Act a bad provision of law? And if it is a bad provision of law in itself, what happens when a bad provision of law meets a corrupt judiciary, a corrupt police force, and ubiquitous poverty? What happens when these two meet? What is this mess that you get into? So I stopped asking. I did not get into the question of should drug consumption be a criminal offense at all, because I couldn't find an answer. So I just gave up on that question. So there are times that rabbit hole will attract you, but you need to stop, because you know that you are not going to find, you have found certain answers that are solid answers that you can actually stand by, that your research is going to be able to bolster, and beyond that is now not your scope. So within the scope of, say, this study that we did, we kept a very limited scope on how drug use is being implemented or how drug use is being criminalized in Bombay. It was a very small, narrow scope, and we said within this scope of project, let's see what questions we find. What I do want to say to this, and this is from experience, that the narrower your scope of project is, the more you define the scope, the better your research is likely to be, because then you're not bogged down by 500 other things that you could be saying.
Right. So there's another question which I think is really interesting. So, this is okay. So the question is, do you think that most of the researchers, research papers and literature get burdened by the ideologies of the researchers and writers?
You can't escape it. You cannot escape the biases that you come with. You have to recognize them and acknowledge them upfront, but you can't run away from them. I don't think there is any such thing as completely unbiased or a research that is divorced from the person writing it. Given again, like if I'm going to be talking about drug use, criminalization in Bombay, I'm already coming with a lens of saying that this is not a good thing to do. And that's the whole idea of hypothesis, right? Your hypothesis already shows your bias. So you can't escape it. You can be aware of it and you can keep checking it and making sure that it doesn't overwhelm your writing, but it is never going to be divorced. And
Right.
that's entirely on you. You have to make sure that you're not overwhelmed by it. And again, this is now me getting a little tangential. The times and how polarized we are right now, getting bogged down and letting your biases determine your research entirely are very, it's like, it's the thing that we do now. It's the world that we live in. So this is like a bias that you have to constantly check and constantly be aware of. That otherwise your research, if you don't check your, if you don't constantly keep checking in.
Right, right. So we'll take two more questions and then we can move
All right.
forward. Right. Uh, okay. How to start research upon a particular section of the NDPS Act on which a person is planning to write a blog?
Can you give me a more like a more like a better, like a more detailed example of what it is? Is
Right.
that an,
Yeah, that's the question. So, Lokesh, can you, elaborate this question? We'll take it up. Okay. Right. So there's a question by Shruti. She's asking, I would like to know how to bridge a gap in a gray area of law where you hardly have any case laws existing or existing legal research. How do you substantiate the need to have laws in the said gray area?
so are you saying that there is no legal research on that point, or that no law exists on that point? It
Both.
depends. So if no law exists on the point, and it is like social malice or social malice that needs to be tackled or bettered, as societies, our go-to for social reform is law. So I think that that bit of research is fairly easily answered, because we are so trained and conditioned to think of social reforms through law that it won't take much of an argument. It won't take much for you to build on that argument. For like, top of my head, we didn't have a sexual abuse law for children for until 2012, I think, or 2000, yeah, 12. So we didn't have POCSO until 2012. They used to use section 377 and 376 and 354 for convicting for sexual offenses against children. So the fact that there is this area which is being there is this whole social evil that is happening, and we are using some backhanded techniques to be able to get to these perpetrators, is the argument that we're making to fill that void, to have that law. That's like one thing when you don't have a law at all. When you don't have legal precedents or any sort of commentaries or whatever on the law, then, because that's actually the kind of research that I'm more attracted to, when there isn't that much legally that has been said on a certain issue already. That's when things get very exciting, because now the field is open to you, right? So then my suggestion to that is to always go to legislative debates first. Go to why that provision of law was drafted in the first place. You might not find answers there either, because they might not have discussed it at all, but very often they do discuss it. They tell you why they have put a certain provision in law. So you'll go to legislative. This is why Constituent Assembly debates are so important, right? To understand why the Constitution is written the way it is, people keep going back to CADs, especially researchers. And that's what you do for all laws. You look at the context in which the law was set, why it was set, what it meant to do. And that's when empirical research becomes so important, is that at this point, then you see, after so many years, after we have reached this point, what is the law doing today? And if the law is doing a certain thing, are there certain inferences that we can draw from what the law is doing today? And that was the point that I was coming to in terms of importance of empirical research. I'll explain that in a little more detail, but that's what I would suggest one does when there is no precedent research on this issue.
Right now, I think, we can move forward and then we can take some more questions.
Lokesh's question didn't come? All right.
Yeah, I'll have to check. There are 53 questions.
Okay.
Yeah.
So then the next point that I had just started on saying is data-driven research. Now I'll club data-driven research and fieldwork in this one point that I want to make, is data-driven research tells you what's actually happening. The problem with legal research is that we are stuck with doctrinal research, where we look at precedents, we look at reviews, we look at journal articles at the most, but we are not looking at what's happening on the ground. So to really inform your question, to see whether your question is well asked, whether that question can be answered, is to then go to two things, is to go to field work and is to go to empirical research. Now, empirical research can be done the way the death penalty research was done, where we interviewed every single death row inmate in the country and tried to figure out what their socioeconomic status was, what their interaction with the criminal justice system was. And that is in its own form an empirical come fieldwork based research. The method that I have now adopted is to do larger, like the quant analysis that I now do is larger numbers. So now I look at, like, for example, for this Bombay report, I think we looked at some 16,000 cases. My previous report, I think we looked at some 14,000 cases over 2 years. This was over 16,000 cases over 1 year. So the empirical research, or like if you look at say section 27 of the NDPS Act before the magistrates court in Bombay, what are they doing under section 27? How are these arrestees presented before the, so this is what we did. How are these arrestees presented before the court? What is the evidence presented against them? How long does the matter take in court, and what is the disposal in favor of, as in what form of disposal is happening? Are they getting acquitted? Are they getting convicted? What is happening? So this your quant analysis, and then here you need people other than just lawyers to do this for you, because none of us are taught even Excel. So even figuring out plus minus on Excel is hard for us. But that's where your quantitative analysis comes into play. What we then did with fieldwork is saying, okay, now this is what data is telling us. Okay, from just looking at data, this is what seems to be happening. Let's now go to Bombay and figure out and speak to the stakeholders and understand what their experience is. So like we chose Bombay because in 2014, Maharashtra's drug arrests or drug cases had gone from some 3,000 or 2,000 to 15,000. Now, you know that something happened in that 1 year where suddenly numbers have gone from 2,000 to 15,000. They have increased more than 5 times. Something is going on. So this is all that you can tell from data, right? That something is happening. A lot of people are coming before the system. A lot of these people seem to be poor on this whatever. A lot of these cases seem to get finished in the same day. Like the date of institution of the case and the date of disposal of the case is the same. Now let's figure out what is happening. So then we went and spoke to some police officers. We went and spoke to some people, some the addiction centers who were dealing with addicts, and we found out that this was basically the police trying to fill their quota, number of arrests that they have to do in a month, because they were facing pressure from the Maharashtra government to increase the arrest rate, and they just chose the easiest law, easiest provision to go after. You know, everybody on the street is consuming cannabis. It's easy, and since cannabis is a criminal offense, very easy to fill their quota of arrests. Now, this story of saying why it is happening, that the pressure is coming from the Maharashtra government, and then we got access to some government resolutions of that time where the government is telling them, you must work harder, you must prosecute better, whatever, which the police has now interpreted to saying, let's just arrest these people in the middle of the night. They don't have any defense. They're not going to argue. They're not going to do anything. Let's just make this happen. This story would not have come out from just quant data. This story requires you to do field work. So this is why I stress on the importance of field work, because just sitting at your table, looking at resources online or looking at cases is not going to give you the true picture of what's happening on the ground. I'll give you another example separate from this particular study. I haven't been on the field in this. This is more, information coming. One can call it data sort of analysis, because this is information coming from people practicing on ground in different states. But for example, under preventive detention laws in the country, your National Security Act is often used for preventing dissent and for arresting anybody who says anything against the government. But your state-centric preventive detention laws are usually bootlegging laws, where people are getting arrested for bootlegging or for being common criminals who have, like, especially in these in these southern states, these are called the Gunda Acts, and they're usually for bootlegging because they don't have control over bootleggers. So rather than arresting them through the regular criminal justice system, they are sending them through preventive detention because it's faster and it's more effective. They're going to stay inside for longer. So now this information you cannot get from just looking at legislation. You cannot get it from case law review. This you will have to speak to somebody who's working on this issue on the ground. This is why fieldwork is imperative. Whatever one does, one must go and speak to people on the ground so one can inform your research. I cannot stress on the importance of fieldwork enough. So this is the now. Okay, now this is when you have done your research, you have done your literature review, you have gone and gotten your empirical data, you have done your field work, you have informed your information, you have seen the gap that you're filling, and now you have like a story to tell. Data is telling. Now the story to tell is probably the toughest part of research. And I, again, this is something that people, unfortunately, lawyers and law students and young law professionals don't seem to understand the importance of sufficiently, is that how you write your paper from this point. Now you have all of this information. How you write your paper from this point is going to be determined by who your audience is. I have started by saying this, and now I will stress on this very, very much. If your audience is a judge in a court, you are going to write in the legal language that one does in these drafts, which are terribly written. This is the lawyer legalese that we do. So that is what you have to write. You can't write it in better English. You can't write it in simpler English. You can't make it more, communicative, because that's what is expected of you. Now, when I'm a researcher and I'm writing a paper, now I have to see who my audience is. We are very limited in our imagination of who we think our audience is, which is why you see even academic writing of lawyers to be very, very poor and very dense. It is not accessible to your normal regular people. So the reason, like this report that we did, or this study that we did, is in a very interactive, it's only a digital piece. We didn't have anything on paper. It's very interactive, where the visuals are adding to the story one is telling, because we wanted this to be like a piece that lay audience, that people who are not familiar with the law could also sort of understand and grasp from. We didn't want this to be limited to my little clique circle of lawyers, of academics, or whoever who reads the same thing in the same language. So how you write, what story you tell, how you tell it is going to depend on who your audience is, which is what you need to know at the time that you're starting writing. And this, I really urge people to increase their imagination on who these people could be. What the purpose of your research is. Is the purpose of my research to necessarily change the law immediately? Am I writing so that some government official somewhere can sort of take notice of what I'm writing and change the law? Am I writing because I feel that the level or the quality of conversation that I see in media, in whatever, in general people around me is so low. The information that they have, the knowledge that they have is so low, that the purpose of my piece is knowledge creation. It's just for people to know what the actual law is, how it is being used. If the purpose is the latter, then it is upon me. It is my job to make sure that my audience understands what I'm writing. I'm not writing for myself, I'm writing for them. So my audience needs to be clearly defined in my head before I start writing. This is very, very important. Second, which again, this is my great grouse against all law students, is that you don't understand, or often we don't understand, the importance of storytelling. So, in the process of research, and what Monolith also said, like this rabbit hole that you have gone into, you have so much to say, you have so many things that you want to talk about, that you lose sight of what it is, that one thread, that one argument that you want to make, that will tell the entire story from beginning to finish without breaking a link. This, the way law school projects are written, you say this also, you say that also, you bring international precedents also, you talk about some Supreme Court case law, you talk about 5 High Court cases, and then you bring it all together and then you write a conclusion. And that is it. But each heading will have nothing to do with the next heading. This is something we know that we do. So the story that you're telling from beginning, so like the story that I'm trying to tell in my Bombay piece is saying that criminalization of drug use itself has been criticized internationally, because you are harming by sending the person who's an addict to a jail. You are first sending him to a jail and you're not giving him de-addiction services. That seems to be contrary to what the purpose of, like, you think a drug user is a victim, so then why are you sending him to jail? That's one. Now, this is a badly conceived idea. Section 27 of the Act, which makes drug consumption a criminal offense, is written in such a manner which says that anybody who consumes any narcotic or psychotropic substance is a criminal offender and is liable for punishment up to a year. Now, you have just said that this person who consumes drugs is a criminal offender. Now, when is he a criminal offender? Is he a criminal offender when he's caught in the process of consuming a drug? Is it when you find residue in this person? Is it if he tells a friend that 5 years ago he had smoked a joint or he had consumed MDMA? Can you now go after him 5 years down the line on the basis of one WhatsApp chat? It doesn't tell you what that leads to. Then the next point in my story is that what these factors together lead to is that the police has been given a free run to arrest anybody. And then what happens is that when the police is met with external factors, like, let's push up our arrest rates, they go after these people. And these kind of laws make it very easy for the police to go after vulnerable people. And this is the story that I have wanted to tell. In the process, I also wanted to tell a story about marijuana and saying, let's think about why marijuana should be a criminal offense, or consuming marijuana should be a criminal offense at all. But it wasn't fitting in the story that I wanted to tell. So then I decided to tell another story from another lens, where the lens was marijuana, in another report. Then in the process of our research, we found out about Sikkim and how Sikkim has decriminalized drug use, and how Sikkim society is doing so much better because it was grappling with, it was crumbling under drug consumption at one point. But it actually seems to be doing better as society. And we wanted to talk about this because we're like, look, a society has been able to succeed in this, and it's within our country, and let's talk about it. But again, in this Bombay piece, it wasn't fitting in. There was no way for me to talk about it as well. So then I just wrote another paper on Sikkim and said, now this is a third argument that I'm making, which is just a third story. Together they make a larger story, but these are separate stories that need to be told separately. So how you write your story and how your audience perceives it is the most critical aspect of your writing. And I was going to end, but I wanted to say another thing, which I feel is very disappointing about legal research and how we consume research and how we write research, is that our methodology, we need to be very, very clear on what our methodology is, what we did, how we did, and why we did. Why did I choose Bombay? What were the reasons that led me to choose Bombay? Within Bombay, how did I go about selecting my sample size? In my sample size, what tools did I use to analyze? Once analyzed, what were the conclusions that I drew? These are things that your methodology is going to tell you, and your methodology is the one thing that will set you apart, or which will sort of determine your worth as a researcher. It's always your methodology and not so much your findings. Your findings can say whatever you want them to say, but your methodology is the process of your research. This is why I called it the process of research, because the process, step 1 to step 10, your process needs to be right, and your step 10 is likely to be good if your process has been correct. And that's it. That's all that I had to say from my end.
Right. So, Neha, there are a lot of good questions for you. So first is by Karthik. So I think Karthik is one of our students also. So he's asking, what is the difference between legislative and public policy research, as both analyze the law for effective implementation by identifying the law?
Mm-hmm. I don't know the difference. I don't think anybody really does. I think these terms get used interchangeably. And because legislative research, public policy research, all of these things are so nascent. When I was in law school, these things didn't exist. This wasn't a thing that was done. So we are also sort of figuring our way around and figuring out what each is as we go along. But there is no like direct, distinctive two heads right now.
Right. So there's another question by Indrani. She's asking, could you please explain more on how legal research looks like in different area? Now, different area, she means in litigation, in academics, in writing an article. What are the steps that distinguishes it? So she wants to know, how legal research looks in litigation and in academics.
So I think legal research in litigation is fairly easy because you have a very pointed question that you're asking. So if my husband is suing me for restitution of conjugal rights, and if I want to counter that, then I know exactly what section to look at. I know what case law precedent on this has been. I know which Supreme Court has talked about Article 14 and how it infringes on a woman's rights and things like that. And I have a document ready where the only thing I need to look at is legal precedent. And the only other thing that I will look at is legal commentaries. So you will start with your secondary research on legal commentaries, what they say. You will move on to your primary research on whatever that section on restitution of conjugal rights are. You will look at what courts have said, and that is going to be the sum and substance of your arguments. When you're looking at academic research is often intersectional. It is not going to just be law. So you are then going to have to look at, say, say if I'm looking at Article 22 and preventive detention, I am going to look at the Constituent Assembly debates, which is not strictly a legal exercise. It is looking at debates that were being done. I'm going to look at the context of 1947. Why did preventive detention make it to our constitution? What was happening? What did the partition do to the country at that time? What was happening to the very people who were a part of the Constituent Assembly? I will then look at how these laws have evolved over time and what they have become today. So I am at this point not just looking at the law or case law around it. I will also have to do that. I will have to look at an A.K. Gopalan case. I will have to look at what the Supreme Court said on this issue. But that is not all that I will do. I will also look at the social context in which this was set and the social context in which we are today, and why it is particularly dangerous today because of the social context that we are in. So your academic research looks very different because it has to be intersectional by the very definition of what you're trying to do. That's the primary difference, I think.
Right, right. So there is one specific question on the title of your research paper, right? So there are a lot, and when I started the delivery of the course, our specific the legal research and writing course, this was one question which always comes up, that should the title be short or it should be like, a sentence. Okay, so I would like to know your point of view in this.
My point of view on this is that the title should always be short. It should be very pithy. The title should be able to grasp the reader's interest in the first few words. The longer the sentence is, the more the chances are that you've lost your reader.
Right,
So
right.
always short. Moving, like even your sentences in the actual writing, always move towards short, because you have to, again, now especially that we're in this great social media generation where everything is in concise little pieces of information. Even articles give you a 4-minute read time and a 5-minute read time, because you're already telling the reader that this is how much investment we expect of you, or this paper will need. So we are working in a paradigm, or we work in a world where attention spans are short. And if what you want to do is create a conversation or get interest in what you're trying to say, then you have to work within the context that you live in. And if the context is short attention spans, then you have to pander to that and work in that framework.
Right. So I think, even my point of view was this, that it should be understandable by the reader. So think about it as a reader, that if it was a research paper by someone else and if you were the reader, would you like it? I mean, would you like the title? So yeah, a lot of questions around the title. So there's one question by Mrityunjay. Okay, now Mrityunjay again wrote a very good paper as a part of the course. Glad to see you here, Mrityunjay. So his question is how to go about writing the analysis that you made after doing the empirical research. Like how to present the data and the arguments in a coherent manner.
Okay. Now, because this is such a procedure-based question, I'll tell you, this is not going to happen in the first time that you try it. And I don't mean the first paper. I mean, your first draft is not going to do that in most likelihood. It'll take, if you're really passionate about your research and you really want to make a good argument, it'll take at least 5 to 7 iterations before you get there. So my suggestion on how one does it is to, in one place, have everything that you have found in one place, that this is all the information that I have. Then you need to look at how this information relates to one another. Is there a coherent, like if you start with this point and this information and you keep working on it, building all the blocks that you have found together, what is the story that you are telling? There will be a certain, and there is like a thread of argument that you will be forming, given that you are the only person right now who has access to all of this information. So if, I'm trying to think about, okay. So let me not talk about this criminalization of this anymore, because I've already mentioned this. So if I'm going to talk about, say, preventive detention, and I'll limit it to NSA right now. If I say that preventive detention was brought into the Constitution under exceptional times when the Constituent Assembly felt hard pressed or felt like their backs were against the wall and they had to draft this provision in the Constitution. From that point onwards, So this point, the first act that we had was the Preventive Detention Act in 1951, I think, or 1950. From that till today, preventive detention has only been misused. From 1960, we have a lot of writing on this issue, and you see that it has only been misused over time. And when you have a fascist government, a tool like this in a fascist government's hand can spell disaster to your democracy. Now, this is the argument I want to make. This is the bottom line that I want to make, and I will thread what I'm trying to say through different time periods to make this argument. And this is the only way I can explain it, is that all of this information that you have, when you have it in front of you, you know how you've seen these crime dramas where they have like this big board and they have all of this information, and how they're forming analysis based on all of this information, is how this is the same sort of parallel that I would draw. That you have all of this information, you're best placed to look at it and see how the pieces fit together. And pieces that don't fit, let them go. It is fine. There's a lot of research that you would have done. There is a lot of things that you want to tell. Some things you will have to edit out. You will have to, however close to your heart they may be, you will have to let it go. That's the only thing that I can say in answer to what has been asked.
Right, Neha. I think fair enough. So there's another question. So this is, specifically to policy purposes. So factors to be kept in mind while conducting research for policy purposes.
Okay. So policy research is going to, hopefully if the policy research is going to be a paper that you come at the end of it, because say we are lawyers, our strength or our strongest suit is to look at legal precedents, look at legal commentaries, look at do legal analysis. And there can be this one thing of saying just the law analyzed says this, but in a policy and coming out with a truly good whatever paper would really be about consultative processes, where you then include different stakeholders who have worked from different angles on the same point. So if you're going to have, say, like a law on trafficking, as a lawyer, I can talk about what ITPA has, the immoral trafficking prevention, ITPA, whatever that act has done, how it was introduced, what the conviction, arrests, whatever rates have been under it for so many years. But then to have like a truly inclusive understanding of it as a policy issue, I will have to have, people who have worked with sex workers, with migrant labor, with bonded labor, have a consultative process and say, with all of these concerns from the ground, with all of these different angles that we have now, we will have like a thick whatever paper at the end of it, which will address all of these different concerns, which you alone, you have to understand your limitations. Let's not get too ambitious, let's not get too arrogant about what we can do. So a good policy piece at the end of this would be, this is my expertise. I look at law, I look at what law does. I will now have a consultative process with everybody else in different issues, in different areas of work on the same issue, and come together and come up with something which is comprehensive, which is actually acceptable mostly to different stakeholders on the same issue. That's what a good policy paper at the end of it will look like.
Right, Neha. So there is a career question for you. So how to make
I'm very bad at this.
Yeah, but you have switched from litigation to now being a researcher. Okay, so I think you are the best person to answer this. So how to make a career as a legal researcher? So this is the question which have been asked by 2-3 of our attendees. So I think, yeah, people are interested to know about it.
Is so legal research just as an end in itself, where you're just writing legal papers because you enjoy the process of researching and writing on law? Then you're at the point that we are in today. You have very few non-academic positions available on this point. So your best course would be to take on teaching and do research alongside. That's your best career option with legal research, if that's what you want to do. By the time, if your students, maybe in another few years, Vidhi will not be the only one who's doing this kind of research, and CPR and all of these, like 2-3 niche organizations, it would have become a little more democratized, the whole process, and more like we'll have lesser monopoly on this aspect of legal research, and then the world is open. But right now, it's mostly academic institutions.
Right, right. So there's one more question, So we have first year, second year law students who just started their journey, right? And with this entire COVID pandemic, how they cannot really go to college. They cannot access the proper libraries. I mean the books and all that. So they are restricted to the online journals and online articles and all that. So how do you kickstart your journey? If you're in first year, second year, how do you kickstart your journey as a researcher? Because I think this is one question from a lot of students, because the times are such, and secondly, as you correctly mentioned, we are not taught legal research in our colleges. So sometimes we just have to fight our own battle and start it. So how do you initiate that process?
Okay, so I am not super proud of this, but the first thing you will do is just like Google your question. Yeah, we are very lucky right now that there are a lot of young legal scholars who are putting out a lot of blogs on a lot of legal issues, especially contemporary issues where one of my juniors from college, Gautam Bhatia, is a prolific writer on constitutional issues. So you have a lot of good information which might not necessarily, actually I cite Gautam Bhatia in my papers all the time, so I think that's also fine. Basically, you have a lot of blogs and easy writing on a lot of legal issues. You have, well, case law is available to you. Most of you will have access to Manupatra and SEC and things like that. You have access to JSTOR, which will give you, or LexisNexis, which will give you access to commentaries or journal articles on specific legal issues. So you need to make the best use of, then of course you have all these, I don't know whether I'm allowed to say this on whatever, but you have all of these, you have this Sci-Hub, which gives you journal articles which might be under a paywall. You have LiveGen, which gives you access to books that might be too expensive to afford. So you need to sort of get smarter about online resources that are available to you. Start with a Google search, see what these more known people on known legal researchers are talking about a certain issue. There is something, actually, let me get to how one does this, because it's just coming to me. A very good way to do this is if you have found a paper on anything. Let's think about any particular issue on homosexuality. Say you have like this excellent article written on homosexuality. Chances are that they will have a very exhaustive bibliography. They'll have footnotes to everything that has been said. Do back end research. Find that one paper, highlight all the research, the footnotes that they are referring to. Find those footnotes, like the articles that are in those footnotes or the cases that are in those footnotes, read them. And as you do, your building blocks will emerge to you. As in, it is not so difficult after that. After the first 2-3 steps, your building blocks will come on their own. So this is it. Just footnote, or bibliography, and build on that. That becomes your first step of literature review or resource building.
Right, Neha. So there's another interesting question. I don't know if the attendee joined late, but what is the difference between research questions and hypothesis? And this is one question which even I did not know till the time I joined. I think I was in my third year of law school.
Yeah,
So
they don't tell you this for some reason.
yeah.
Research questions are the question. Hypotheses is the answer, the tentative answer you give to a research question. So like, so the first question that we had asked under my previous report was like, do the harsh provisions under the NDPS Act meet the stated objective? Because at the time of drafting the law, they said that, the harsher the punishment, which is the trend we see now, right? Like, let's expand punishment. So like this question that we could ask is, let's increase that has the punishment, like when we have introduced death penalty for the second rape offense, for example. So this question being, do harsh punishments meet the stated objective of reducing trafficking under the NDPS Act? That's my research question. My tentative hypothesis would be that harsh provisions only get applied to low-end traffickers and users and does nothing and does not impact trafficking in any way. This is my hypothesis. This is the hypothesis that I said, or saying that harsh provisions under the NDPS Act have categorically reduced trafficking and have been effective. This is my hypothesis. This is my tentative answer, and I will see whether my hypothesis has been met by my research. It could be rejected or it could be validated. So that's the difference, answer versus question.
So this question is that could there be a possible gap in a research which is just so obvious that it doesn't need to be discussed or addressed?
No, I don't think there is any such thing. I don't think there is ever a gap which is so evident that it doesn't need to be addressed. Things that you might think are evident might be complete rocket science to a layperson. So, if there is a gap, it should be addressed. You can't leave it, or you shouldn't leave it. Or if you are leaving it, then you say it's outside the scope of this piece. I am not. I'm choosing not to engage with it. But that it doesn't merit engagement at all, I don't think that situation really exists.
Right, right. So Neha, one more question. You have been doing research since a very long time now. So let's say I choose any particular topic, and
Hmm.
after reading, after going through certain articles and reports and all that, I kind of narrow down a particular research question. But when I start actually writing about it, I kind of figure out that I am not making any valuable contribution towards that particular research. Then how do you deal with it? I mean, do you change the entire topic, or you try to cover some other aspect?
So this is why I'm so in favor of exploratory research, because an exploratory research is basically like a like a larger question that I have. Again, like I said, that should drug consumption be a criminal offense is a question I started with like a year ago. It's not a question I have been able to answer. It's a question that I hope to answer someday in life, but it's not a question I've been able to answer. But in the course of my research, I could answer a narrower question. So I answered that narrower question instead. It will happen often that the question that you start out with is not the question you will end up answering. So this abandon it, maybe if it is that redundant, yes, but usually modify it. Be open to your questions changing, because when you're stepping into research, you don't know very much. So a lot of rejection, actually, which seems like this hard work that has gone wasted, is actually a good thing, because you know that that's not something you want to engage with right now, or that question itself has led to a dead end. So that research, the exploration that you have done, the different evidence that you have generated might make you help you ask a better question and give you a better answer. So modify, always be open to modifying.
Right. So there's another question, and I think this is very relevant to whatever you have explained till now. So when you're conducting a empirical research, right? How do you like ensure that the sample size which you have selected will actually help you in finding answers to the question?
Ah, that actually I am not the best person to answer, because this is now statistical analysis. And there is, I have myself been trying to study statistical analysis and what sample size is sufficient, and how do you prevent, like if, for example, if I send a questionnaire to my email groups, I am already sending a questionnaire to certain kind of audience, and the responses that I will get might not really be representative of people at large. So
Right.
this question is something that I am so what I have sort of prevented, or I have sort of not gotten into this, because I don't know this myself very much, by just doing an exhaustive empirical. So I just pick a period from, say, January 2019 to December 2019, all the cases that were decided in this time, and then assess them. And like, for example, for death penalty, we didn't do a sampling, we did exhaustive research. Same thing with both my NDPS thesis. Is because I don't understand sampling, I just do exhaustive. But if you wanted to learn this, you would have to learn statistical analysis tools. That's what you'd have to go to.
Right, right. So there's another question. I think a lot of our attendees have asked this. That again, like it's similar. That how do you select the methodology? When you're doing a research, how do you select what method is to be followed? Uh, for a particular topic, should it be doctrinal, empirical? I know it's very difficult. It completely depends on
The
how you
researcher.
perceive it.
Correct.
So yeah, guys, I personally feel that, and I was telling this to Neha before we started this session, that till the last 3 months were left for my LLM dissertation, and that's when my professor told me to do empirical research, and I was like, I cannot do it because I had no time left. Where would I go, to conduct the field work? I mean, even if I reach out to my friends, I would not get any quality responses.
No.
It will be like, they're just filling it for the sake of filling it, the form. So I think it completely depends on the researcher, like
Meanings.
yeah, how do you perceive the topic? Right.
So, I want to just add to this that the
Yeah.
beauty of research, and I won't say legal research, the beauty of research is that that it's research, right? You could do anything with it. It's about how you want to explore a question. What are the tools you want to employ in exploring a question? So don't make this so dogmatic. Your questions, let the idea of exploration excite you. When you enter something with the idea of exploring and finding answers, then you will like just that excitement, or the things that excite you will drive where your research goes. Doctrinal is perfectly fine. It can be very enriching, as is empirical. I just like empirical so much more because then I'm like, numbers are telling you. And also sometimes when you want to make an argument or when you want people to pay attention, numbers really really influence people. So because it was so happenstance, it happened at a time, like my research came out at a time when this Riya Chakrabarti had just exploded, like the whole drugs thing had exploded. The reason why it got a lot of traction from media is because I had numbers. I could say 97% have done this and 87% have done this. So this 87%, 97%, whatever, this really makes a difference in people's minds. We are used to saying, oh my God, so many. So again, and that again will come back to saying what your audience is. What do you want the audience to do? Do you want to just have a conversation amongst academics who want to discuss ideas of Kant and Plato and whoever? So then doctrinal and theory is perfectly fine. But if you want to make an impact and influence people, and people say, oh my God, this is such an issue, empirical is the way to go.
Right, right. So we'll take one, two, 3 questions more. There are a lot. There are 83 questions,
83, I saw.
but I'm just selecting the questions, broader questions. So one major question was that, let's say you are writing on NDPS Act, right? And you don't know who I am, but I am a prospective reader of your report, right? So do you keep in mind the your reader base, and how do you determine it? That it can be anything, right? It can be anyone. It can be your teachers, it can be your colleagues, it can be law students, and it can also be people from the non-law background. So do you also keep in mind your targeted audience before you start writing?
You must have a target audience in mind before you start writing,
Right.
because how you write will change, will depending on your audience, how you write will change. So the first report on NDPS Act, which was like this 80-page mega thick report, I know that the only people who are reading it are either law students, actually probably that's it, or people who want to look at whether my report makes sense, something like that. Like maybe like 20 people in the world have read it, because, and I have, there is enough academic credential and rigor in that research that I know it can be cited for academic purposes, but it is unlikely that somebody will pick it up for an interesting read. It's never going to happen. Okay, now I wanted my audience to be different this time, so I have written like an 800, rather than having 80 pages, which is God knows some 50,000 words, or whatever that is, or I have the same, like I have an argument which I could have made over 20 pages in 1,000 words. So because I wanted my audience to be different, so I wrote it differently and I wrote it shorter. So of course, somebody could still cite it in an academic paper if they wanted to, but that is not my intended audience necessarily. So your audience will always determine how you write, and you should know it before you start. This is, as I keep saying, this is the onus of the researcher to know.
Right, right. So one more question. When you're writing any research, or let's say you're writing any report, at the end, when you conclude it, do you think it is also necessary to put out your suggestions, about that topic, what you have found out, during your research, like your suggestion about the topic, that I differ from this topic, and this is my suggestion. This is what I think as a researcher.
Depends on what your paper is about, right? Is trying to do, right? Is it trying to just talk about a theory of law, then you're just going to talk about the theory of law. Are you going to talk about what John Stuart Mill said on legal paternalism? Then you're just going to say that. Are you talking about how the NDPS Act is, employs reverse burden of proof, and that makes it easy to arrest and convict people? Then I'm going to have my suggestion on saying, well, it should be, the burden of proof should be on the prosecution to prove the case and not on the person to prove that he's innocent, because we are turning into prove guilty until proven innocent. So that is my suggestion. That is my recommendation. But then that is entirely dependent on what the purpose of the piece is. These are again not dogmatic answers one way or the other. And in no circumstances can you say something and then in your conclusion say, I have found all this, but I personally differ. I do not agree. That is like unacceptable. You can't do that.
Right, right. So there are one last question for you. A lot of times you are writing a paper, you have put down your arguments, you're on the verge of completing it, but then suddenly you realize that, oh, there is one point which I'm not able to express properly. It's somewhere there at the back of your mind, but you're
Don't
not,
express it.
yeah, you're not able to write it down in words. So how do you personally deal with such situations?
I abandon it. If I feel that I have seen sometimes, you know that you have an interesting idea in the making, but you
Yeah,
haven't made it yet.
yeah,
Okay, so it's just, it's just not the time yet. It'll happen, but it's just not going. Don't force fit it. If it's not fitting, if you haven't been able to articulate it, if you haven't been able to articulate it in your brain, you're not going to be able to articulate it on paper at this point. So just forget it. If you've still made a solid argument, which is
right.
sufficient without that one point, let it go. You can make it at a later stage in life.
Right, right. I think Neha, we have broadly covered everything. So, guys, if any of your questions are unanswered, I'm posting the email address. Feel free to reach out to us on webinar@lawoctopus.com. Please feel free to write us an email with your question. We will answer your question because, in there are so many questions. There are 85 questions which are still unanswered, but I've majorly covered the important questions which were asked. I'm not saying your question wasn't important, but due to paucity of time we cannot cover all the questions, but feel free to post it on webinar@thelatelaw.com. We'll take it up.
Can I
Neha,
share? Can I just answer one quick question which has been
yes,
asked,
yes,
which I think
yes,
is very important?
please,
Is
please.
how to avoid plagiarism. I think this is a very, very
Yeah,
important thing.
yeah,
Um, so you must always cite the source. If the idea is not yours, if the sentiment or what you're saying is not yours, it's not your analysis, you must cite it. If you're paraphrasing it, footnoting it is sufficient. If you're going to say it verbatim, put it in quotes so that it's known that this is somebody else is saying and you're just quoting the person. But if there is something that can be attributed to somebody else, you must attribute it. It's just that simple. Attribute whatever should be attributed.
right, right. I completely agree with that. So, guys, again, plagiarism is something, which I think is sort of a crime. You are just stealing someone's idea.
Intellectual dishonesty, yes.
Yeah, exactly. I mean, if Neha has written on NDPS Act and I know that, she has worked on it, I just cannot go to her report or her paper and copy whatever she has written and say that, hey, I have
It's
written a
fine.
piece on this, right? Because that's like you're not putting your intellectual labor, which you should do as a researcher. So,
It's theft. It's
yeah,
theft of an idea. So you must
yeah.
not steal somebody's idea.
Yeah, definitely. So again, like she mentioned, follow that. If you are paraphrasing, yes, footnote it. The best part would be to write your own analysis, rather than just taking it from here and there. Write your own analysis. Uh, don't I think we have that fear of judgment, that what
Yes.
will people think and
Yes.
will this contribute towards the research. I think that will come, that you won't have that fear of judgment, I think, after writing 50-60 papers. But when you're just starting, don't.
Nobody is judging you.
Yeah,
Nobody is judging you. Nobody is good at what they do. You get good, especially at something like this, you get good as you go along. And I don't think one ever gets that good that one doesn't have scope to learn or write or better, whatever. So nobody is judging you. The fact that you're putting information out there, the fact that you're writing is good enough. Just do that.
right. So guys, I have 3 papers pending. I have not touched it from past 3 years. It's all 3/4 written, half written, just started. But I don't think so I am getting the time, but then I want to write it when I am in a correct state of mind. I just don't want to read and copy paste something. So yeah. So Neha, thank you so much. It was a wonderful session.
Thank you for having
Great,
me.
yeah, great insights about research about your particular topic, and I'm sure we have had so many questions. This session will add value to anyone who's looking to start their career as a researcher, or they just want to students who want to start researching about topics and become researchers. So guys, thank you so much for attending. We will have future webinars around this topic, around legal research and writing. Feel free to register for that. We love hosting you guys. And also, Neha, thank you so much for joining in. I
Thank you.
personally really loved the session, and looking forward to more such sessions. Guys, if you have any questions which you think was unanswered, please feel free to drop us an email on webinar@lawoctopus.com. The website is on the email address is posted on the chat box. And yeah, we'll see you in the next session. And also, we have a course specifically on legal research and writing, so I'll just write it down here as well if you guys want to go check out the contents. Okay, Neha, thank you. Have a
Thank
nice
you.
day. Yeah,
You
thank you guys.
too,
Have a
guys.
nice day. Yeah.